Rule 5, Rule 5, preliminary proceedings. Rule 5 from the Colorado Rules of Criminal Procedure, preliminary proceedings. A, felony proceedings. 1, procedure following arrest. If a peace officer or any other person makes an arrest, either with or without a warrant, the arrested person shall be taken without unnecessary delay before the nearest available county or district court. Thereafter, a felony complaint, information, or indictment shall be filed if it has not already been filed without unnecessary delay in the proper court, and a copy thereof given to the defendant. Number 2, appearance before the court. At the first appearance of the defendant in court, it is the duty of the court to inform the defendant and make certain that the defendant understands the following. The defendant need make no statement, and any statement made can and may be used against the defendant. The right to counsel. If indigent, the defendant has a right to request the appointment of counsel or consult with the public defender before any further proceedings are held. Any plea the defendant makes must be voluntary and not the result of undue influence or coercion. The right to bail if the offense is bailable and the amount of bail that has been set by the court, and the amount of bail that has been set by the court. The nature of the charges. So that was the right to a jury trial. There's 9 things here. The right to demand and receive a preliminary hearing. It went from 6 to 7. Okay. The right to a jury trial. The right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that the offense charge was committed by the defendant. 9, if currently serving in the United States Armed Forces or if a veteran of such forces, the defendant may be entitled to receive mental health treatment, substance use disorder treatment, or other services as a veteran. 3, appearance in the court not issuing the warrant. If the defendant is taken before a court which did not issue the arrest warrant, the court shall inform the defendant of the matter set out in Section A2 of this rule, Rule 5, and allowing time for travel, set bail returnable not less than 14 days thereafter before the court which issued the arrest warrant, and shall transmit forthwith all papers in the case to the court which issued the arrest warrant. In the event the defendant does not make bail within 48 hours, the sheriff of the county in which the arrest warrant was issued shall return the defendant to the court which issued the warrant. 4, preliminary hearing, county court procedures. Now, this part is where Michael Gonzalez, the chief judge of the 12th Judicial District, he read this sentence wrong. And, as a scientist, I leave the possibility that I may be incorrect about something, so I do want people's feedback. But I had asked, hey, do I get a preliminary hearing? No, that's not really for this. He asked, hey, you got any questions? And then later on called it a ruling. So he totally fucks you over. Hey, you got any questions? Yeah, what's the process? Oh, you don't know the process, huh? Well, we're not going to give you a fair due process. How about that? You're not going to give me a preliminary hearing? Nope, we didn't read about it. We didn't give you a preliminary hearing. We didn't do any of that shit. No, but it's not big enough to do a plea bargain, right? It's not big enough. It's too big to do a plea bargain. It's too big to, for it not to be a felony. It's a $5,000 bond. So it's this big enough. Firing 3 warning shots at some piece of shit driving around your house acting like he's going to commit crimes. Firing 3 warning shots at some piece of shit acting like he's going to commit crimes. That's big enough to say that's a class 5 felony. That's big enough to have 5 men with 5 guns come to your house. That's big enough for a $5,000 bond. That's big enough to get arrested and jailed, fingerprinted, spent the night in jail for 24 hours. That's a big enough, accusation for a protection order. Make sure all guns and bullets are out of the house. And then no restorative justice, no pretrial diversion, no sirree. We got the VRA we got to respect. So it's too big of an accusation to get any kind of plea bargain. Too big of an accusation. You know, it's big enough for all that shit, but is it big enough for a preliminary hearing? Is it big enough for a preliminary hearing? No, it's not. That stupid fuck is going to say he doesn't know, that I don't know due process either. Motherfucker, you don't know due process. If I said, hey, Michael Gonzalez, you ruled over a district that has, committed crime after crime after crime. You're running over a district. In fact, I reported a crime directly to you. That didn't even get discussed. So Michael Gonzalez runs a district where the crime runs rampant. Truth and justice and peace? Is that what we're... No, that's not the point. It's anarchy. Whoever's got lawyers, they do whatever the fuck they want. Whoever can, is willing to risk. Ugh. So he read this one sentence wrong, and let me explain to you how he read this sentence wrong. Are you ready? So this is Rule 5, Preliminary Hearing, County Court Procedures. Every person accused of a Class 1, 2, or 3 felony and a felony or Level 1 or 2 drug felony complaint has the right to demand and receive a preliminary hearing to determine whether probable cause exists to believe that the offense charged in the felony complaint was committed by the defendant. In addition, only those persons accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony by felony complaint, which felony requires mandatory sentencing or is a crime of violence as defined in Section 18, 1.34 or 6, or is a sexual offense under Part 4 of Article 3 of Title 18 CRS, shall have the right to demand and receive a preliminary hearing to determine whether probable cause exists to believe that the offense charged in the felony complaint was committed by the defendant. However, any defendant accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony who is not otherwise entitled to a preliminary hearing may request a preliminary hearing if the defendant is in custody for the offense for which the preliminary hearing is requested, except that upon motion of either party, the court shall vacate the preliminary hearing if there is reasonable showing that the defendant has been released from custody prior to the preliminary hearing. Any person accused of a Class 4, 5, or 6 felony or a Level 3 or 4 drug felony who is not entitled to a preliminary hearing shall, unless otherwise waived, participate in a dispositional hearing for the purposes of case evaluation and potential resolution. The following procedure shall govern the holding of a preliminary hearing. And 1, 2, 3, 4, 5. We're going to read some more of this, but... So you have a 10-step felony procedure in Colorado. 10-step felony procedure. You have the arrest or the summons, and that gets the whole thing started. And then you have the advisement of charges, bail bond hearing and arraignment, disposition, preliminary hearing, pretrial readiness, the trial, and then sentencing. I believe that's the 10 steps. Now, Judge Michael Gonzalez is going to agree with me that 9 of the 10 steps is consistent, right? So he's going to say, I don't know, I didn't go to law school. Well, the cops didn't go to law school either. But since I didn't go to law school, then therefore, I can't understand basic English. And as a citizen, Jesus Christ, does he assume that all the citizens are just supposed to put their heads in the sand and not try to understand a goddamn fucking thing? Only if you've gone to law school do you get to use the courts. That's not what the Colorado Constitution says. The Colorado Constitution says that anybody who is injured gets to use the courts. So Michael Gonzalez doesn't seem to know Colorado Constitution. He doesn't understand U.S. Constitution. He doesn't understand due process. So he read this sentence incorrectly. So when it comes to a preliminary hearing, so Michael Gonzalez agrees with 9 of the 10 of the steps that I just listed. He agrees with me. So I know 9 of the 10 of the steps of due process, but preliminary hearing, he had made an aside. He pretended it was a ruling. because he didn't want to hear anybody else. He's so fucking smart and he knows every goddamn fucking thing in the world. It's just good to reinforce your knowledge about anything. The whole motions hearing is about finding defects in the institution of the prosecution. Well, he's going to say it has to be like motion to suppress, not the process. How's the defects in the process not defects in the institution of the prosecution? So for the preliminary hearing, they do make a distinction. So the very worst of the worst, right? Level 1 or 2 drug felony, class 1, 2, or 3 felonies, they all get preliminary hearings. Class 4, 5, or 6, or level 3 or 4 drug felonies, however, they only get a preliminary hearing if it's a crime of violence, or if it's a sexual offense, or if it requires mandatory sentencing. He skipped the or. There's or, and then there's a or. So there's 3 different reasons that somebody with a class 4, 5, or 6 felony or a level 3 or 4 drug felony would get a preliminary hearing. Under this clause, if you're in custody, you also get a preliminary hearing too. So Judge Michael Gonzalez, and he was like, Judge Gonzalez, very insecure, very, very insecure. Mandatory sentencing. He didn't read that part. And then when he read that sentence, he tried to squish mandatory sentencing with crime of violence or a sexual offense. Well, that requires mandatory sentencing like the crime of violence and the sexual offense. He tried to squish that together. And I said that he read that sentence wrong. I wanted to argue my goddamn case, motherfucker. Worked so hard on them goddamn motions and he wouldn't even give me a minute to, I had different oral arguments and the written arguments. I worked on this shit. But instead, he's a cheater. He didn't want to hear the oral arguments because he's a cheater. He's a cheater. He doesn't understand due process. He doesn't understand, what's good for the goose is good for the gander. He doesn't understand fair procedures. He doesn't understand that. Because if I accuse Michael Gonzalez of allowing people to felony menace, dozens and dozens of times, Michael Gonzalez is covering up a felony animal murder. They killed Tecumseh. Some people in Costilla County killed Tecumseh, and Michael Gonzalez, maybe he hasn't heard about it yet, but the police officers and the DA investigators and a whole bunch of, I find it very shocking that he hasn't heard about it yet. At the very least, the people that work under him, they covered up a felony, and they kept covering up felonies after felonies after felonies. So there you go. There's an accusation for you, Michael Gonzalez. You're covering up the person that killed my dog. You're covering up a bunch of felonies that happened subsequently after that. Are you entitled to a preliminary hearing? That's the accusation. Now you get arrested. Now you have to go through the whole process. The bail bond hearing, then the advisement of charges, the arraignment. That's a piece of information, right? By leave of court, get some judge to say, okay, sign that affidavit. And now Judge Michael Gonzalez has to go through the same criminal justice system that I just went through. If he believes in the rule of law, if he believes in fair and impartial administration and procedure. So he tried to squish those 2 sentences together. He ignored the mandatory sentencing part. Because Class 4, Class 5, and Class 6 felonies, they all have minimum sentencing. So you get fined so much and you get jail time so much. And they're felonies. Felonies are the big fuck. You got, traffic, you got petty, you got misdemeanor. Then you got fucking felonies. It's just incredible that basically they're saying little felonies don't get a preliminary hearing. If you're in custody, if you committed a huge felony, you got a preliminary hearing. So, the King Super Shooter, Claudia Camacho, James Holmes, all these killers that, killed people, did this terrible, heinous, criminal bullshit. They're entitled to a preliminary hearing. They're entitled to a preliminary hearing. except upon motion of either party, the court shall vacate the preliminary hearing if there is a reasonable showing that the defendant has been released from custody prior to the preliminary hearing. Any person accused of a class 4 or 5 felony or level 3 or 4 drug felony who is not entitled to a preliminary hearing shall, unless otherwise waived, participate in a dispositional hearing for the purposes of case evaluation and potential resolution. The following procedures shall govern the holding of a preliminary hearing. And then 1, 2, 3, 4, 5, 6, 7, 8, and the rest. So, yeah, I'll read the rest of them. But yeah, that's the discrepancy. So I believe that a preliminary hearing is part of the 10-step felony criminal procedure. Nice 10-step, procedure. So everybody knows what, who's on first, what's on second. So everybody knows what the hell's going on. That's better. That's way better. The dispositional hearing for purposes of case evaluation and potential resolution. In good faith? They didn't try to do that in good faith. Potential resolution? Bullshit. Motherfuckers like, I'll send you the email right out. I'll give you the email if you just say, the attempted felony menacing. Like it's the greatest, like it was a deal of a lifetime. Like it was a suitcase of $1 million. Here's a suitcase of $1 million. So, yeah. Judges aren't supposed to involve themselves in plea negotiations either. So, now I'm going to read the rest of this. Number 1, within 7 days after the defendant is brought before the county court for or following the following of the felony complaint in that court, either the prosecutor or the defendant may request a preliminary hearing. Upon such request, the court forthwith shall set the hearing. The hearing shall be held within 35 days of the day of setting unless good cause for continuing the hearing beyond that time is shown to the court. The clerk of the court shall prepare and give notice of the hearing or any continuance thereof to all parties and their counsel. Number 2, the preliminary hearing shall be held before a judge of the county court in which the felony complaint has been filed. The defendant shall not be called upon to plead. The defendant may cross-examine the prosecutor's witnesses and may introduce evidence. The prosecutor shall have the burden of establishing probable cause. The judge presiding at the preliminary hearing may temper the rules of evidence in the exercise of sound judicial discretion. That's another thing about a preliminary hearing. It's weighted on the side of the prosecutor. It's weighted on the side of the court and the prosecutor. The whole point with the preliminary hearing, right? I just said that Michael Gonzalez is, running a system that covered up the felony murder of my puppy and then several other felonies after that. That's a serious accusation. And if you lived in an actual world where, a sane world where you had, truth, justice, and you had a fair criminal procedure, well, that's an accusation. So that means he needs to go through the 10-step procedure. Now, does he get a preliminary hearing? Now, he just got arrested, bail bond hearing, right? Did all the rigmarole. Now, does he get a preliminary hearing? He's, official misconduct. He's covering up felony crimes. For what reason? Because he's lazy? Because he doesn't know right from wrong? Why would he cover up felony crimes for such a long time? Dozens and dozens. I called the police. There were several times I initiated a complaint. It went nowhere. Number 3, if the county court determines such probable cause exists or if the case is not otherwise resolved pursuant to a dispositional hearing, if no preliminary hearing was held, it shall order the defendant bound over to the appropriate court of record for trial. In appropriate cases, the defendant may be admitted to or continued on bail by the county court, but bond shall be made returnable in the trial court and at a day and time certain. All county court records except the reporter's transcript, notes, or recording shall be transferred forthwith by the clerk of the county court to the clerk of... Fucking fuck! shall be transferred forthwith by the clerk of the county court to the clerk of the appropriate court of record. We'll finish the rest of this in a minute.